We're back on Energy Matters, brought to you today by the Coalition for a Secure Energy Future. Find out more about their good work on the issues we've talked about today from the Great Plains and Power ND Energy Conference on stopping the Clean Power Plan and letting members of Congress know what needs to be done. Also brought to you by Ide Bailey and by our friends at Bakken Energy Service. Speaking of doing everything in one's power to stop the EPA, the Attorney General of the great state of North Dakota is here to talk a little bit about the ongoing efforts to take on the EPA in court. Mr. Attorney General, Wayne Stenehjem, how are you, sir?
Wonderful. Good to be with you again, Scott.
Good to be with you. And let's first, maybe for the benefit of folks that did not get a chance to hear your talk today with the folks at the event about our response to 111D, which, I mean, could we find 10 people in a coffee shop anywhere in North Dakota that knows what a 111D means? But new power plants, old power plants, or existing power plants, we are on a full frontal assault from the EPA right now, aren't we?
We are, and probably you wouldn't find 10 people at random who know about it. But those who do know about it and who are trying to provide energy for a state and a nation that needs it are well aware of what 111D will do. And what it is a major expansion of federal authority and regulation of the energy sector here in North Dakota and all across the country in ways that will, first of all, not have any appreciable impact on the emission of carbon dioxide in the globe, which is where these things matter.
In other words, they won't do what they're intending to do.
They won't do much of anything. Even their own scientific research shows that the impact would be negligible. But it is at a cost of tens of billions of dollars, which of course are always ultimately paid by the consumer, the person who uses the electricity to heat their home and cook their meals and all of those kinds of things. And so we're very concerned about it. And I was here to speak as Attorney General because we're looking at pursuing litigation on this, just like we have with the waters of the U.S. and the anti-fracking rule that the Bureau of Land Management attempted to implement, claiming in this case that the federal Congress has never passed a law that gives authority to the Environmental Protection Agency to enact these massive, sweeping kinds of regulations. That's number one. And number two, the other complaint that we will have, and that I think will have some legs when we get into court, is this. The rule when it initially came out required an 11% or so reduction in carbon emissions from plants in North Dakota. We thought that it would be a tough slog for us, but that perhaps we could do it. And that is the rule upon which we commented, and the EPA comes out and pretends they're having hearings and listening to people about concerns that they have. But when the final rule came out, the actual reductions that would be required in North Dakota is quadruple that, 45%, and it's at an amount that is simply not attainable.
I want to ask you about that, if you don't mind me interrupting, because I talked to Tony Clark, who was obviously in a position to know, and he said, look, any fair reading of that suggests that was a full, assault on North Dakota, specifically an attack on North Dakota. I mean, he compared it to like the New England states. Completely different deal. So, I mean, from a legal standpoint, I'll be an armchair lawyer here. Is that not in and of itself something to target?
That's what I think. That is exactly right. That's why we have a couple of legal claims that I think are very good ones. The first one is that Congress didn't ever authorize them to adopt this kind of a rule. And in fact, there's another statute in the federal government that prohibits it. But in this case, whenever you start out with a proposal for a regulation and then ask stakeholders and state governments and others to come in and comment on it, and then you come in with a rule that's wholly different than what it was that you initially asked somebody to comment on, that runs into problems under the Administrative Practices Act. Courts have said so frequently, and I think they certainly would in this case, because the ultimate rule has to be what's called a logical outgrowth of the initial rule. Well, this rule didn't look, it was like, did you ever send a kid off to college and they come back at Christmas and you hardly recognize them anymore? That's what happened to this rule. We commented on the initial rule, and then when it came back, nobody recognized it because it wasn't even close to what it was that we were permitted to comment on in the first place. That's a problem for the federal government, and I think that that's something that will give us adequate room to make a valid legal claim, in addition to the claim that the statute doesn't even authorize it in the first place.
By the way, I'd still love my kid, but I don't love this piece of legislation.
Right.
Or proposed rule or whatever. Isn't that
Not recognize them.
Yeah, no kidding. So I've lost track of how many lawsuits are in the pipeline here against the federal government. Obviously, the waters of the U.S. is a big one, and a victory you shepherded that now has rippled all across the United States, and another court victory on that today I want to ask you about in a moment here. But just quickly run me through all the areas that you're either in litigation or considering litigation.
Well, we have at least 14 lawsuits that we have commenced and are in the middle of, either through North Dakota specifically or in conjunction with other states that share the kind of interests that we have for providing energy for a nation that needs it. And so there's, I can go through them individually. I think one of the most significant ones, first is going to be this 111D rule that comes up. But the other one that I think I've characterized as one of the most obnoxious and objected to rule that I have ever seen is the waters of the U.S. And I was very proud here and of course what that involved for anyone who might not have heard about it is a broad usurpation of authority that had traditionally, since the nation was founded, belonged to the states to control the waters within their own borders. And now comes the EPA and the Corps of Engineers and claim that they have authority over broad swaths and in fact much of North Dakota, including the gullies in western North Dakota and the prairie potholes that don't connect to other tributaries but are regarded by the EPA as regional treasures, and they therefore claim that they're entitled to regulate those as well as waters of the United States. It is a remarkably unsupportable position. And so I worked with some of my colleagues, got 12 other states to our litigation here in North Dakota, went to the federal district court in Fargo, got an injunction prohibiting the preliminary injunction prohibiting the defendants in that case, the federal respondents, from implementing the rule. We have an injunction. We were the only state at the time, we were the only coalition at the time that was able to get that injunction.
I want to ask you just a little bit about that and then keep going with where you're going on all the rest of these. But I heard from some people that watched the court activity closely that those that work for Judge Erickson were unimpressed with the way in which the federal government was dealing. So I thought that was ironic that you got, obviously a federal judge and, in your case, a state attorney general litigating against the EPA and the federal government, and they're like doing things that I guess a first-year law student would know you don't do. Is that accurate?
Well, it is. I think that in the lawsuit we had against the Bureau of Land Management, it was more pronounced than it was anywhere else I've ever seen, because they brought in, and this is the anti-fracking rule that we heard in that we brought and was in Casper, Wyoming, and I was at the hearing there. Well, the federal government comes in. They don't have anybody that knows anything broadly, so they bring in one lawyer, he knows the Clean Air Act. They bring in another lawyer, and he knows the National Environmental Policy Act, but nothing else. And then, so they had 5 lawyers, and they each knew only about their own little separate area. So even when the judge asked the question, if it spilled over into somebody else's expertise, then they had to call that lawyer up and try to answer the question for him. It was remarkable, and I don't think that even in the case now of the waters of the U.S. that was heard in Fargo, that the federal taxpayers were well served.
So tell us what happened today, or the news came out today regarding the waters of the U.S. rule and some key victories as well.
So there's about 21 lawsuits that are pending complaining about the waters of the U.S. rule, and by 31 different states. And so the EPA came in and they filed a motion with a group. It's a group of 7 judges, and it's called the Multi-District Litigation Panel, when there's national litigation, to seek to consolidate all of these cases in one case. And in this particular instance, they thought Washington, D.C. District Court would be a perfect place. We disagreed. We said, we have a injunction here. Our judge is ready to proceed. We're ready to proceed. And the judges, all 7 of them, it was unanimous, said we are not consolidating this case in Washington, D.C. We're going to let these cases proceed. They aren't that complicated. They're issues of law, and we're going to let them proceed. And so now we're asking the judge today to issue a scheduling order to get our hearing brought forth and get what I hope will ultimately be a permanent and final injunction against this obnoxious rule.
So in other words, you continue to fight this battle in Judge Ralph Erickson's courtroom in Fargo, North Dakota, U.S. federal court.
That's right. And then, of course, I would expect they will appeal it to the Eighth Circuit, which is fine. And I have said from the beginning, this is probably a case that should go and will go to the U.S. Supreme Court, and that is fine. And in the meantime, the defendants, the federal government, is enjoined from enforcing this rule. And that's a good thing.
Oh, man, it's hard to know where to begin, isn't it? And is this just the future for, I mean, even obviously this is going to go well beyond the Obama administration, and who knows who takes the helm, but regardless, a lot of this stuff will continue even if there's a Republican president that comes in, right?
It does matter who gets elected president. And part of the blame belongs in the Congress, in my view, because they have failed to address all of these things and specifically spell out what it is that they expect these agencies to do. They should not have a life of their own and authority to do things that they want to do, irrespective of what the elected officials and elected representatives of the citizens want. That is not the way our system is supposed to work. So when you have that void that does exist on the federal level in Congress, there's always somebody, and especially now with this administration, happy to come in and fill the void. And that's exactly what we've seen with the anti-fracking rule, this rule, and the Waters of the U.S. rule.
Before I let you go, I would be constitutionally mandated to ask you a question about whether or not you might be seeking the governor's chair. Move across the hall to the other office there. I know last time we talked, you had given some indication that there was serious consideration. I do have a source that a committee form may have been actually filed with the Secretary of State's office that suggests there is a Governor Stenehjem committee. Is that accurate?
Well, you don't really need to have any secret source. It's a public record, and it was I filed that with the Secretary of State. The reason for that is that, though I haven't asked, I have had a lot of people who have sent checks hoping that I will run and sent checks to Stenehjem for governor. And when that happens, you're obligated by statute to file a committee. And so I thought that was the logical thing to do. But I think the assumption might be that if I weren't running, I'd have sent those checks back, and I didn't.
Did you just tell us you're running for governor?
No, I didn't. No, I didn't. Well, we're moving in that direction, Scott. I think that's fairly clear, and a lot of the things that we're talking about here that we want to do, I want to make sure that we're continuing. North Dakota is a wonderful place, and energy is just one facet of what it is that we can do here, that we can provide jobs and taxes and energy for a nation that needs it. We're in great shape here, and I'm very optimistic about the future, and no matter what, I want to be part of it.
Last time we talked about this, I asked you about the timeline. You mentioned that you were continuing to visit with your wife. Are we down to days now, or what kind of a timeline on it being this is happening, and get out the banners?
If you think I can't sidestep that question when you ask it, when I'm much better at doing so when Beth asks me. But we're moving in that direction, Scott. I think that's a fair thing to say, and I don't want to play, play when or play games about it. I do think most people think campaigns are too long already, and that if we make a final determination, even November, early December, that's plenty of time for a campaign.
Thank you, sir.
Anytime. Always good to chat with you.